We have some bills for first reading, and I will invite the sponsor of the bill, and that is pursuant to Rule 128, and that is Honorable Saro Pendi. And the bill, Minister of Finance denied to give a certificate of financial implication, and subsequently, we have had to invoke Section 76(4) of the Public Finance Management Act 215 for the bill to be brought to be read for the first time. And based on that, because the bill has spent 60 days, the bill is ready for reading. Honorable Sarah, can you present your bill?
Thank you, Right Honorable Speaker. Right Honorable Speaker, on the 8th day of November 2022, this House granted me leave to introduce a private member's bill entitled the Alcoholic Drinks Control Bill. And Right Honorable Speaker, I have had members saying that we want to stop people from consuming alcohol. I want to let you know that the object of this bill is to regulate the manufacture, sale, and consumption of alcoholic drinks, prohibit the sale of supplying alcoholic drinks to children, and other related matters. Right Honorable Speaker and members.
Sarah laid the bill. We don't want the objects of the bill that was presented.
Thank you, Right Honorable Speaker. Right Honorable Speaker, as you have clearly indicated, we relied on the 60-day rule, and this bill was gazetted. It's now my pleasure, honorable colleagues, to lay the Alcoholic Drinks Control Bill 2023. I beg to lay.
Thank you.
I beg to lay. I beg to lay the bill entitled the Alcoholic Drinks Control Bill 2023, that it be read for the first time. Thank you, Right Honorable.
Thank you. Thank you so much, Sarah. In furtherance to Rule 1291 of the Rules of the Procedure, the bill is accordingly referred to the Committee of Health and Trade. It was seconded. The problem you never hear. Okay, let the drunkard second. Is the bill seconded? Seconded by Honorable Kotogo, Honorable Honorable Linos. I can see only the people seconding this bill. How about Alioni, Honorable Alioni, Honorable Macho, Honorable. So the bill is seconded. Thank you so much. And we will give you the Health Committee and Trade, please handle this bill together. We've always got a benefit when two committees are handling a bill, especially that has an implication on health. Next.
Item 3.2, Amendment Bill 2023.
Yes, procedure matter.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I have previously sought leave to amend the Constitution. The first Constitution amendment. I brought a motion here, and you referred it to the Minister for Constitutional Affairs. I made another constitutional amendment. I submitted it to your office. And Right Honorable Speaker, on this floor, the Minister of Justice and Constitutional Affairs indicated to this House that they are going to have a Constitutional Review Commission, and for that reason we cannot amend the Constitution piecemeal. You have even referred all our motions. Myself, I presented the motion to you, regarding ministers who are in court and, still holding the office. The Honorable Akol Anton hurdles a constitution amendment. The Honorable Karubanga Jacob Atenyi. Right Honorable Speaker, the reason you referred this was because I believe in your own document, you were referring the Constitution Review Commission. So, Right Honorable Speaker, it therefore beats my understanding when I see the executive coming up with a constitution amendment just for particular article, so that we can have the commissions which are affected by the mergers passed. So, Right Honorable Speaker, since we were assured that there will be a Constitutional Review Commission to handle these amendments, can we first have that Constitutional Review Commission? Short of that, Right Honorable Speaker, then you will allow all of us to present our motions to this House. Thank you, Right Honorable Speaker.
Thank you so much, Honorable Saropendi. I had a number of constitutional amendments that were on my table, and I have written to Attorney General. I have not got a feedback up to date. Can we hear from Attorney General? What is the urgency that requires a piecemeal constitutional amendment?
Thank you very much, Right Honorable Speaker. My sister Sarah is shooting from the hip. I do understand her concerns, and several other people have expressed those concerns, just like the Speaker herself has written to us. But, Right Honorable Speaker, this bill is being moved by Ministry of Public Service, which is handling rationalization. It is being moved by Public Service, which is handling the issue of rationalization. To deal with the proposed merger of the Equal Opportunities Commission and the Human Rights Commission. Meanwhile, the rest of the comprehensive amendments that we have all been studying as a country, those proposed by law reform and those that we shall pick from the field, can be dealt with at once in one comprehensive move, because some of them may require referenda. So I'm simply requesting that you allow us to proceed with this. Thank you.
Clarification.
Chair, legal.
Thank you very much, Right Honorable. Let me also take this opportunity to congratulate you and having joined our association. Right Honorable, if we are to have an amendment to this constitution, time is now. And we need a comprehensive amendment. And now that government thinks this is the particular article that must be amended, and others also have interest in amending certain provisions, I think the only time we can have government to introduce these amendments is now. Time is now. Right, Deputy Attorney General, go back, consider all the necessary amendments, come up with the Constitutional Review Commission, and they handle the amendments, and this should be done. I don't see an urgency as far as this issue is concerned. Why only this? Do we think others are not important? I think the Deputy Attorney General should go back and they bring to us all the necessary amendments. Giving us only this, I think is not fair to this country. I agree with all the colleagues that we need a comprehensive amendment to the Constitution, and the time is now. Thank you very much, Right Honorable Speaker.
Nathan.
Thank you, Right Honorable Speaker. I think we should treat each other properly. The Cabinet has always been behind rationalization. This House formed a committee, interim committee, ad hoc committee. We reported here. We couldn't debate because the Minister of Public Service said he wanted 60 days. This House has never.
There are several bills. We have the Constitutional Amendment Bill 2023 that seeks to harmonize the Human Rights Commission and equal opportunities. Then we also have the rationalization of government agencies, that is the Repeals and Amendments Bill 2023.
What I'm saying, the issue of bringing this, it's because they want this one to go together. So we can't allow it. We must be respected. We must be given a chance to debate. Where are you taking us? To Egypt. Right, Honorable Speaker, we can't afford to go backward. I think this is a high time where we respected each other. We can't have this parliament and you are a cabinet in a cabinet. Let's respect each other. We are all members of parliament, except you have other responsibility. Nothing else, really. This is the same parliament. We are the same. We are the same. And when I see Honorable Mururu Mukasa, a senior NRM cadre, doing all these things, you are taking us backward, and this is what we have been here before. I am a senior person here. We sat here at the parliament. We deliberated about UCB up to midnight. Somebody said he would say it on a Sunday, and he would say it on a Sunday. Now what are we doing? Are we going back to look for a commercial bank? Cooperatives and so many things. Kindly, Madam Speaker, I don't want this House to be taken for granted. The members of the cabinet are up to something bad for this country. The country belongs to all of us. We want these amendments to come at once. Let's have a stake in this country. You can't handle it single-handedly.
Which amendments do you want to come at once?
No, what I'm saying, the commission, this amendment of the Constitution is talking of commissions because they are here. He wants to abolish Opportunities Commission, Human Rights Commission, and the Law Reform Commission. Can you imagine a good government going out with a commission for the laws? You, especially you. This is the commission that prepares all the laws for this country. And now you sit somewhere, you come and want to bring it under the ministry.
Honorable ministers, you'll come.
So, to cut the long story short,
Honorable
Right,
members,
Honorable Speaker,
honorable members,
I have reasoned the point of order.
honorable members, honorable members, Honorable Oduria, Honorable Leon, I have said we can disagree, but respectfully. If the member has got up and he has an order, let's give him a chance. He says what he wants. At the end of the day, it is this House to decide. Let doctor bring his order. We shall give another person to say something, and we move on. If the House is saying we are not ready for the amendments, we will not force the House.
Right, Honorable Speaker, I am the elected member for Chinchiz East in Kanungu, so nobody can stop me from speaking on this microphone. I rose on a point of order, Madam Speaker, and there has been a discussion within the cabinet, which has also found space here, and the government did promise that we shall follow the rules to come with Parliament. And now on the order paper, you are allowed to have this Constitutional Amendment Bill and also the Rationalization Bill, which gives the chance to Parliament to be part of this discussion. Is it in order for the Honorable Byanyima, who is very senior, to impute that by the Cabinet bringing these issues to Parliament, then we are undermining the Parliament? Is it in order? Because this bill...
Honorable Chris, much as we have this on the order paper, this morning I actually passed the message to Honorable Muruli, where you have a repeal and amendments of over 40 entities. Now, we have each of these entities has a sectoral committee. Tell me, how are you going to handle this whole booklet, this whole one, with the 40 entities? Meaning that we are going to have a committee of a whole house, where if you're talking about UNRWA, it will look at public service together with the committee of infrastructure. When you're talking about health, you're talking about public service together with what? Of health. How are you going to do that? You needed to do the things one-on-one. One-on-one. Huh? You're not going to bring everything on minibus. Huh? It helps you in doing all this. And different laws. Yes.
Right Honorable Speaker, before I really answer that question, allow me, Right Honorable Speaker, on behalf of the Ministry of Public Service and the entire service, to congratulate you upon becoming a Nalongo. Congratulations indeed, and indeed, you have also to congratulate the Salongo for that very commendable work that has been done. Right Honorable Speaker, Honorable Honorable Sereko is also a Salongo. He has acclaimed he's a Salongo. Yes, please, congratulations, Nalongo, congratulations, Salongo, and indeed all the Salongos in this house, and the Nalongos in this house, and the Nalongos in the country and outside this house. Congratulations. You have acceded to that very prestigious position of being a Nalongo. And allow me to use the very important congratulatory message that is used in this part of the country. Bweza, bweza, bweza ba Nalongo, bweza ba Salongo. Right Honorable Speaker, indeed, I must...
Honorable members, listen to Honorable Muruli, and Honorable Muruli is one of the senior legislators, and because he's a senior, he's going to listen to the House.
Yes, and I always listen to the House, Right Honorable Speaker. I must apologize, Right Honorable Speaker, that I did not receive your advice this morning. However, I have had the opportunity now, with your indulgence, to receive it now, of how the approach that we are going to use in handling this omnibus bill. Yes, there are many agencies involved. Unfortunately, there are various committees involved. And I think, as you are asking, part of the answer of how we are going to approach this was given. You gave it yourself. And given, of course, enough time, we can engage the various committees involved with each of these agencies. And then we come up finally to the House and debate this omnibus bill and pass it if you so wish. Right Honorable Speaker, the question of not debating, I think, Right Honorable Speaker, is out. I think it is part of our procedure that we debate. And this is to allay the fears of our senior colleague, Honorable Byanyima, who is a senior legislator, that there is some kind of stampede and that there is not going to be any debate at all. Really, God forbid
There's a procedure
that there will be no debate. I would like to assure...
Thank you, Right Honorable Speaker. Rise on a procedure point. Right Honorable Speaker, you constituted a select committee in this House. This select committee used public resources to look at the proposed mergers and presented a report in this House. And Right Honorable Speaker, you deferred debate, awaiting government to go and sit and come back with a response to the proposals so that we can debate. We have never debated that report, Right Honorable Speaker. Instead of now the minister coming to maybe present their position on the report, we are seeing a bill. Right Honorable Speaker, are we proceeding well as a House when you constituted a select committee whose report has never been debated? And instead, we are now looking at, before we debate, we are going into handling bills.
Honorable Minister, we had a select committee in this House. We had a report and we are awaiting from Cabinet on the position of Cabinet. It does not stop us from debating if they are brought in a correct way. And that's why I'm telling you, Minister, don't bring them in totality, omnibus. Bring entity by entity, such that we'll compare our report together with your report. Yours is a bill. Bring a bill of UNRWA. If you want to repeal UNRWA, it is this House who know whether it will repeal or not. You get it, eh? You bring your proposal. For us, we also have our proposal as a House. Then we shall sort it from here. But you don't bring it in omnibus. Isn't that what, Honorable Bianye, isn't that what the House...
That's what we would have loved, because there is no better person here other than the sector committee.
Yes.
Each sector committee would definitely have a better judgment on whether an agency should be merged or mainstreamed or rationalized.
If
But
we have
thank you.
different reports, UNRWA, you have NITAU, you have what, we will refer them to different sectoral committees. And those sectoral committees will bring those amendments. Whether we are amending an act of UNRWA, whether we are amending an act of NITAU, whether we are amending an act of whichever. So we want them separately. Yes. Honorable.
Thank you very much. And I join those who are congratulating you and the people who Chimbiri congratulate you. Honorable members, I want to appeal to Honorable Muruli to listen to me and the ministers. Honorable members, this omnibus gratuity, pension, and statutory obligations like paying the debt is less than the money collected by this country, which is, we are in a danger, we're in a red mark. So now when you go to rationalize and you again retrench people, it means it is a cost on the pension, which the government of Uganda cannot sustain. So they needed to tell us that we are going to rationalize. So many people are going to lose their jobs, and so much money will be paid, and in what period? Instead of having a pension and being promised gratuity, which they will never get. The third point is that the government, they have taken over government, meaning that all of the bills will be handled by the one minister.
Local government. That will be handled by local government.
No, the omnibus.
I mean public service.
I'm saying the omnibus is going to be handled by one minister, yes. Meaning that is irregular. So we need justification for the cost and the political implication. Because when the population is growing, services cannot be shrunk. We need the services. I thank you.
That is the rationalization of government agencies and public service, public expenditure. First of all, we need to know the cost implication. I don't think government is even up to date on the RAPEX policy. RAPEX policy. Government is not up to date. You need to give us information about it. On the cost implications of that policy, We need to look at the structural implications, the legal, the service delivery, and then the implications on the multi-year commitment that we are going in. That's what we need to get from you. Shema, honorable members, I think we're even wasting a lot of time on this. A lot of time on this matter. My 2 hours have gone. Can you go and do what the House wants of you? That's number one. Attorney General want to know when the Constitutional Review Commission will be in place. We need a commission, comprehensive. We need it, okay? And we need this not to be taken by one ministry, by different ministries. If it is a repeal, if it is an amendment, we are going to do it.
Also, right, Honorable Speaker. But before I sit down, I'm of cost implications regarding this bill from the Minister of Finance. That means that we have taken cognizance of the cost implications of what we are going to do. Right, Honorable Speaker, I would like to say that yes, this is the right moment. We are going to follow your advice. We shall consult further regarding this omnibus bill. Right, Honorable Speaker, I am mindful of the fact that we are taking too much time over this matter and that really you have 2 hours. I beg that, yes, we go and consult and then we shall come back. And of course, yes, according to the policy, the omnibus bill has actually captured the policy direction of rationalization. Thank you very much, Right Honourable Speaker.
If I could refer this bill to.
Thank you very much. With the permission of the Honourable Minister, Right Honourable Speaker, it's not the first time to have an omnibus bill on the floor of this House. And one way of handling it, because we chose to bring it as an omnibus bill, but with the different bills to be amended. One way of doing it, don't say no, because we decide as a cabinet,
listen.
can be, Madam Speaker, that you can refer the bill to the committee, the committees pick what belongs to them. Say, just hold on. Say the bill on UNRWA will be handled by the Committee on Infrastructure. The bill on NITAU will be handled by the Committee on ICT, like that. It won't be the first time it is handled in this House.
Is there any challenge with you bringing different bills, then we hand it to each minister bringing a bill on different
There is
sectors?
a Chinese who said it doesn't matter whether a cat is white or black, as long as it catches mice. We're trying to save time. Yes. Yes. So we looked at those options, Madam Speaker. One option of which
now, let's not use the Chinese way. Let's use the Luchiga way.
Yes, the Luchiga way.
Let's use the Luchiga
Right,
way.
Honorable, we looked at these options because one option was each minister to bring the bill affecting his ministry.
You bring
And then the other option was to put them together to save time. But then at your level, the Speaker, yes, you can make a ruling to instruct the different sectoral committees to handle bills which fall under them. At the end of the day, the committees would have handled the bills which fall under them. That's what I'm saying, whether white or black, provided we achieve what we want.
Katesh, you had...
Clear. We are ready to support government and look at the rationalization, but we must be orderly with proper information.
Madam, thank you, my colleague, for giving way. Madam Speaker, as per your directive and your advice, Mr. Minister of Public Service, we are not a rubber stamp parliament whereby you bring something omnibus and we pass it, we cannot pass a law that can affect our people, because bad laws affect always regimes in power. And we cannot allow our regime of NRM to lose popularity because there is something you are smuggling in.
Next item.
Procedure, Madam Speaker.
Item 5.
Madam Speaker, I beg your indulgence.
Item 5. Bill second reading. The Petroleum Supply Amendment Bill 2023.
First, the Petroleum Supply Amendment Bill 2023 was read for the first time on 31st October and referred to the Committee of Environment and Natural Resources. The committee considered the bill and its honourable members listen.
Right Honourable Speaker and colleagues, I would like to move that the bill entitled the Petroleum Supplies Amendment Bill 2023 be read for the second time.
Is the motion seconded? Seconded by Honourable Namiliango. Honourable Nathan. Second the bill. Honourable Moding, Feta. The bill is seconded by the Prime Minister, by the leader of government business, by Whip, by Minister of NIRA, by Lok on this side, Linos, by Omara, by Royal Guard, by Energy, Orone, Attorney General, Odria.
To the Uganda National Oil Company to be the supplier of the products to the oil marketing companies. And the main objective is that we want to move away from the system that has been multi-layered by our brothers in Kenya, so that we shorten the import and supply route. It is a very short bill, Right Honourable. It has 4 provisions which I'm introducing, and it is basically to improve on the supply of petroleum products so that we keep the country wet, so that we are sure that at any time we shall be having the products in the country. So security of supply and also managing of the costs. I beg to support.
Thank you so much, honourable members. The chair is ready to present.
And honourable colleagues,
Right Honourable Speaker, allow me, as a medical doctor, also congratulate you, but also quickly add what you've already alluded to. Before I present my report, I want to congratulate you for the twins. But I want to say that, as you rightly guided, Right Honourable Speaker, we don't need to overstress you. And I would like to appeal from the outset that as we are considering this bill, we don't overstress Mama.
Honourable members, listen to a doctor.
Because the Right Honourable Speaker, because of your great love for this country, you came here to handle this very important business. But you are still within your period when the organs need to get back to their normal position. And so my appeal is that we do the very best in the shortest time possible. Right Honourable Speaker, I beg to lay on table the minutes of the proceedings of the Committee on Environment and Natural Resources as we scrutinized this bill. I beg to lay.
Thank you.
Right Honourable Speaker, I want also to report that there is a majority report and a minority report, and as it is the practice of this House, I beg that both versions be accorded time for presentation.
We are having a summary of both reports because the emphasis must go on committee stage.
Thank
The
you.
reports that you have are only informative. They only give us information.
Thank you, Right Honourable Speaker, for that guidance. Right Honourable Speaker, this is a report of the Committee on Environment and Natural Resources on the Petroleum Supply Amendment Bill 2023. Right Honourable Speaker and Honourable colleagues,
or their dissent, and a statement of reasons shall be appended to the report of the committee. Right Honourable Speaker, I am a member of the Committee on Environment and Natural Resources. The committee, in its meeting that considered the bill yesterday on the 13th of November 2023. Right Honourable Speaker, the attendance of that meeting, as per the book of attendance of this Parliament, was 23 members. And I beg to lay on table a copy of the attendance of yesterday's committee meeting, which has those members. Right Honourable Speaker, in the proceedings of that meeting, we analyzed the report, the bill clause by clause, as guided by the chairperson of the committee. And we voted on all the clauses. And Right Honourable Speaker, for all the clauses that the committee assessed and voted on, the majority members who were in the attendance, as per the minutes that the chairperson of the committee has laid, were...
Order, Mr. Speaker. So, Madam Speaker. Order, Madam Speaker.
So,
order, Madam Speaker.
Honourable members, please sit. Honourable members, what is your procedure matter?
Right Honourable Speaker, my procedure matter is that the chairperson of the committee is purporting to read a report as though he's reading a majority report, and yet I have the majority report in accordance with the proceedings of yesterday.
How many signatures do you have in your report?
Thank you, Right Honourable Speaker. Right Honourable Speaker.
How many?
Right Honourable Speaker.
Read for me the names of members who are in your report. Read for me the names.
Honourable Feta Geoffrey.
Is Feta?
Honourable Akamba Paul, myself.
Those are 2.
Honourable Kwizera Eddie.
3.
Honourable Ogwari Polycarp.
4.
Honourable Kaya Christine Nakimwero.
Absent. I am in receipt of the letter Don't speak like your speakers. I am of receipt of a letter saying we are out of parliament. So don't tell me those kind of things. Read the members who are in the parliament who have not written to me.
Right Honourable Speaker, I don't know which member.
I am saying I am of receipt from opposition that we are not in the parliament. So don't smuggle in the signature.
Right Honourable Speaker, I don't know the members that.
Okay, that one is absent.
Attended yesterday. I don't know who
Christine is
wrote to
absent.
you and who did not write.
Listen, Christine is absent. Go next.
Honourable Naure Asha
is absent. Is absent.
Tebandeke Charles.
Absent.
Honourable Nyakato Asinas.
Absent.
Honourable Akena James Jime
is present.
Honourable Kamuntu Moses
is present.
Right Honourable Speaker.
How many are those?
Right Honourable Speaker, can I be accorded time?
I am saying how many.
I
want us to go in a systematic way. Those are 6 members you have. Those are 6 members you have. Chairman, how many do you have on your list?
Thank you, Right Honourable Speaker. Right Honourable Speaker.
Honourable members.
And Honourable colleagues.
Honourable members, this is not a do or die. Whatever you're doing in this house is not a do or die. And and I've always warned my members, whichever members come knowing that for us we are going to fight for this, do accountability. How many members do you have?
Right Honourable, I have 22 members.
Can you read your report? Then Honourable Kamba will read his report.
Thank you.
I have not asked him to read the names. Stop it. Are you assistant speakers?
Right Honourable Speaker, thank you for...
Can I have a summary of your report? Have a summary of your report. I wish I was you members. That's why I like Nathan. Nathan is only waiting for committee stage. Now, these reports are informative. You're going to get just basically, we are not going to consider a report. Yes.
Right Honourable Speaker. Right Honourable Speaker, much as we need this bill to pass, we must be mindful.
We have not said we need...
what I'm saying is that I have had the benefit of reading the decision of Zake against Attorney General as far as issues of attendance, signing of the reports are concerned. One, the courts guided that before you sign on the report, you must have attended the proceedings. Now, Right Honourable Speaker, can we find out, because we don't want these mistakes to be made, can we find out how many members attended and at the same time appended their signatures? Because if we proceed to just assume that 22 have signed, when actually out of 22, few of them attended, or out of the 10, few of them attended, then, Right Honourable Speaker, we shall be proceeding contrary to the guidance given by the Constitutional Court in the case of Zake against Attorney General.
By the way, for your information, we are in court because of that case.
The background to this bill, Right Honourable Speaker and Honourable colleagues, is that the Petroleum Supply Act was enacted in 2003
Honourable Panado,
to provide...
Honourable Macho, first of all, you're a smuggler. I am going to smuggle you out. Now that one who is not seeing, are you seeing the person reading? Okay, let Otala read the report. Now, Panadol and Macho, I don't want to hear you talking. For the next 2 hours.
Thank you. Thank you, Right Honourable, for your guidance to the House. I was saying that the Petroleum Supply Act was enacted for the supervision and monitoring, importation, exportation, transportation, processing, supply, storage, distribution, and marketing of petroleum products, establishment of the minister responsible for the petroleum sector as the regulatory authority, licensing and control of activities and installations, safety and protection of and the environment in petroleum supply operations and installations, encourage and protect fair competition in the petroleum supply market, repeal certain related laws, and for connected matters. Right Honourable Speaker and Honourable colleagues, the Act, however, does not empower the Uganda National Oil Company, UNOC, to solely import and supply all imports to the licensed oil marketing companies of petroleum products for the Ugandan market. Right Honourable Speaker and colleagues, UNOC is a limited liability company owned by the government of Uganda. It was established under Section 42 of the Petroleum Exploration, Development and Production Act and Section 7 of the Petroleum Refining, Conversion, Transmission and Mainstreaming Storage Act, both of 2013, and was incorporated under the Companies Act of 2012 as a limited liability company, with the shareholders being Ministry of Finance, Planning and Economic Development, with 49% of the shares, and the Ministry of Energy and Mineral Development with 51% of the shares. The mandate of UNOC, Right Honourable Speaker and colleagues, among others, includes handling the state's commercial interests in the petroleum subsector, managing state participation in petroleum activities, managing the marketing of the country's share of petroleum received in kind, evaluation of new upstream, midstream and downstream ventures, optimizing value for its shareholders, and developing in-depth expertise in the oil and gas sector. Right Honourable Speaker and Honourable colleagues, the lack of empowerment for UNOC to be the sole importer and supplier of Uganda's petroleum products has contributed to instability of petroleum product supply in Uganda, unpredictable pump prices, and financial stagnation for UNOC, which has curtailed its business progress. Right Honourable Speaker, it is from this background that the Petroleum Supply Act of 2003 is being amended in order to empower UNOC to be the importer and supplier of all petroleum products for the Ugandan market. This is intended to ensure security of supply of petroleum products, improve petroleum product stock holding levels within the country, and contribute to the competitiveness of retail pump prices. Right Honourable Speaker and Honourable colleagues, the object of the bill is to amend the Petroleum Supply Act of 2003 to empower the Uganda National Oil Company Limited to be the supplier of all imports to the licensed oil marketing companies of petroleum products for the Ugandan market for purposes of ensuring security of supply of petroleum products, to improve petroleum product stock holding levels within the country, and to contribute to the competitiveness of consumer and retail pump prices. Right Honourable Speaker, the National Development Plan 3, 2020-2021 to 2024-2025 is rooted in a vision of a transformed Ugandan society from a peasant to a modern and prosperous country within 30 years. The aim of the sustainable development of petroleum resources under the plan is to attain equitable value from the petroleum resources and spur economic development in a timely and sustainable manner. Right Honorable Speaker and colleagues, the plan notes that Petroleum Authority of Uganda and the Uganda National Oil Company were operationalized to regulate the petroleum industry and manage the business or commercial interests respectively. This is in line with Vision 2040, which aims to transform the Ugandan society from a peasant to a modern and prosperous society. The bill therefore intends to actualize the intention of the National Development Plan 3 by enabling the Uganda National Oil Company manage the business interests of the country by supplying all imports to licensed oil marketing companies of petroleum products for the Ugandan market. Right Honorable Speaker, I want to go now to committee analysis, observations, and recommendations. Right Honorable Speaker, this part of the report will examine the proposed clauses of the bill, their constitutionality and relevance in light of existing laws and policies, court decisions, and the mischief they intend to cure. Right Honorable Speaker, regarding amendment of objectives of the Principal Act, Clause 1 of the bill seeks to amend Section 3F of the Principal Act, whose objective is to encourage and promote fair competition within the petroleum supply market, to eliminate discrimination or preferential treatment of any participant, and to prevent monopolistic control of any segment of the supply chain. The clause further proposes to insert a new objective, I, to facilitate the Uganda National Oil Company or such other person nominated by the minister with cabinet approval to import all petroleum products destined for the Ugandan market. The committee noted that currently Uganda imports 90% of its petroleum products through Kenya and 10% through Tanzania. The country has an annual consumption of 2.5 billion liters of petrol, diesel, jet A1, and kerosene, with an annual growth of 7%. On average, petrol takes the biggest share of imports, followed by diesel, then jet A1 and kerosene, in that order. The said petroleum products are purchased by Ugandan companies from Kenyan companies, which have been operating under the open tender system until April this year, when Kenya moved from open tender system to government, dealing directly with the countries where they now import their petroleum products. The open tender system, OTS, was guaranteed by the Ministry of Petroleum and Mining in Kenya, which is responsible for regulation of imports of all petroleum products in Kenya. The Ministry of Petroleum and Mining in Kenya instituted the quantities for the Kenyan domestic market for onward transit to neighboring countries at a 60-to-40 ratio, respectively. In essence, 60% of all the fuel imported through Kenya is retained in the Kenyan market, and neighboring countries, including Uganda, Rwanda, and the Democratic Republic of the Congo, have to share the 40% share allocation. The system currently from the overseas refinery to the Ugandan oil marketing companies, with the companies including Aramco, ADNOC, and ENOC as the first layer traders from the overseas refineries. Companies that constitute the second layer include Galana, Gulf, and Oryx Kenya. The third layer includes Total, Vivo, Starbucks, Rubis, and City Oil, and Haas, which then supply to the Ugandan importer oil marketing companies. Each of these companies infuses a profit margin, which is ultimately fed into the final pump price. Right Honorable Speaker, as you can see, that's a diagrammatic representation of the path of petroleum product importation into the country, but also there is the lower part, which is demonstrating what we are going how we are going to eliminate a number of middlemen when UNOC is empowered. Right Honorable Speaker, I now move on to talk about the volume of monthly petroleum imports for Uganda. And that chart basically it shows the volume of petroleum products imported by Uganda every month. And the source is Ministry of Energy and Mineral Development. Inability to purchase directly from the refineries leads to an extra markup on Uganda's fuel from Kenyan companies. Insecurity in supply for petroleum products and inability to directly negotiate for petroleum prices with the refiners, which inevitably contributes to high and unpredictable pump prices. It would be because we had observations also.
That is committee statement.
By restricting the importation and supply of petroleum, that since the inception of UNOC, it has lacked sufficient funds to execute its mandate of managing the state's commercial interests in the oil and gas sector, including importation and supply of petroleum products from oil refineries abroad. Although the current endeavor is meant to build capacity of UNOC to import and supply petroleum products to the Ugandan markets, it still needs additional resources to be able to deal directly with international refineries. The committee therefore recommends that government enhances funding for UNOC to enable it independently execute its mandate. Possible working partnerships for UNOC. The committee was informed that oil refineries only deal with big companies of high financial standing. For this reason, even Kenyan companies participating in the open tender system, including Vivo Kenya, could not manage to have a standalone arrangement with refineries. A typical refinery will require a standby letter of credit or bank guarantee issued by one of the 50 top banks in the world for volumes of at least 356 days. In Uganda's case, the current annual import of approximately 2.5 billion liters would require a bank guarantee of at least US dollars 1.5 billion. The committee therefore recommends that UNOC should explore possible working partnerships with willing entities that have developed capacity in transportation and storage of petroleum products. Right Honorable Speaker and colleagues, regarding establishment of the Technical Petroleum Committee, Section 8 of the Principal Act 2003 provides for the establishment of the Technical Petroleum Committee that consists of a chairperson, 8 other members who possess qualifications and expertise in respect of petroleum supply and related matters to be appointed by the minister. In addition, Section 9 of the Principal Act outlines the functions of the Technical Petroleum Committee, among others to include advising the minister on proposed legislation, technical standards, and specifications relating to petroleum products and the supply chain, and developing and submitting to the minister proposals for the improvements of the petroleum supply policies, systems, regulations, technical standards, and codes of practice. Right Honorable Speaker and colleagues, the committee noted with concern that 20 years since the enactment of the Act, the Technical Petroleum Committee has never been set up. The absence of the committee indicates a significant gap in the oversight and advisory mechanisms for the petroleum supply and related matters, which impedes effective performance of this subsector. Right Honourable Speaker, we therefore recommend that the Ministry of Energy and Mineral Development should operationalize the Technical Petroleum Committee as stipulated in Part 3 of the Principal Act 2003. I now move to elimination of intermediary oil marketing companies. The committee noted that there is an option of UNOC dealing with the oil refineries directly. This would eliminate all middlemen from the supply chain. We therefore recommend that in the long term, UNOC should explore opportunities of direct engagement with refineries. This shall minimize costs and increase stability of petroleum product supply into the economy. Right Honourable Speaker and Honourable colleagues, I beg to report.
That if you don't agree with the person reading, or if you don't agree...
I'll go straight to...
So what are you clapping for?
I'll go straight...
You know, at one time they
compliance
say...
of the bill...
I'm asking, what are you clapping for? You become kind of people who say that so long as they can say aye. Now, for you, that is the kind of...
Compliance of the bill to the National Development Plan 3. The NDP 3 seeks to increase the competitiveness and strength of the private sector to drive sustainable and inclusive growth. As a key to national development policy, the NDP 3 seeks to ensure that the government works with the private sector to ensure that the resource-led industrialization process is both sustainable and beneficial to its citizens. NDP 3 advocates for the prevention of non-tariff barriers in regional markets, competition policies, and laws that encourages innovations, enforcement of standards, and the proliferation of counterfeits. The proposed amendments to the Petroleum Supply Amendment Bill, Ignore Act, are therefore not in conformity with NDP 3. Committee analysis, observations, and recommendations. This part of the report will examine the proposed clauses of the bill, their constitutionality and relevance in light of existing laws and policy, court decisions, and the mischief they intend to cure. The analysis is based on the thematic areas as provided for in the bill, as well as new proposals to the bill. Amendment of objectives of Principal Act. Clause 1 of the bill seeks to delete Section 3 of the Principal Act, whose objective was to encourage and promote fair competition within the petroleum supply market, to eliminate discrimination or preferential treatment of any participant, and to prevent monopolistic control of any segment of the supply chain. The clause further proposes to insert new objective I to facilitate the Uganda National Oil Company or such other person nominated by the minister with cabinet approval to import all petroleum products destined for the Ugandan market. Committee observation. The committee noted that currently, Uganda imports 90% of its petroleum products through Kenya and 10% through Tanzania. The country has an annual consumption of 2.5 billion liters of petrol, diesel, jet A1, and kerosene, with an annual growth of 7%. On average, petrol takes the biggest share of imports, followed by diesel, jet A1, and then kerosene. The said petroleum products are purchased by Ugandan companies from Kenyan companies, which have been operating under the open tender system until April 2023, when Kenya moved from Otis to government, dealing directly with countries where they now import their petroleum products from. The OTS system was guaranteed by the Ministry of Petroleum and Mining in Kenya, which is responsible for regulation of imports of all petroleum products in Kenya. The committee noted that whereas the proposal in the bill is to have UNOC as the sole importer and supplier of all petroleum products for the Ugandan market. Interaction with the Minister of Energy revealed that UNOC has no financial capacity to sustain the business of importation and supply of petroleum products for the Ugandan market, and it has executed an agreement with Vitol Bahrain EC, an international trading company, as the sole supplier of petroleum products for UNOC for 5 years, locking out all other competitors from the Ugandan market. The committee noted that handpicking of Vitol Bahrain EC and creation of a monopoly for it to supply UNOCO was not justified. Submissions from entities like HEC International Limited, E3 Group, asserted that their capacity to finance the supply of petroleum products to UNOC, Mascrine Limited expressed their ability to offer a bank guarantee to UNOC so that UNOC directly deals with oil refineries. Details in the minutes and attachments. Had government invoked the provisions of the PPD Act and advertised the offer, a number of entities, including UNOC, would have expressed interest, and the country would have got the best offers rather than limiting it to only one company. Better still, the government should have considered government arrangement. Further, the committee observed that there is a possibility of government dealing directly with the refineries without involving intermediary oil marketing companies. A point in case is Zimbabwe, where a veteran company called CFC Energy Private Limited entered into agreement with the Rafan Refinery Limited. I would like to lay on table of this kind of arrangement of Rafan Refinery with the Zimbabwean country. I beg to lay. Right Honorable Speaker and colleagues,
What are you
the
laying?
committee noted that.
What are you laying?
Right Honorable Speaker, I'm laying a copy of the agreement that a company belonging to veterans in Zimbabwe entered directly into an arrangement with the refinery called Rafan Refinery 2, and it was able to succeed, yet it was just a mere private company, not even government. The committee noted that whereas inability to purchase directly from the refineries leads to an extra markup on Uganda's fuel from Kenyan companies, insecurity in supply of petroleum products, and inability to directly negotiate for petroleum prices with refiners, which inevitably contributes to high and unpredictable pump prices, the proposed monopoly is not a preferable option since there is no competitiveness in price against a monopolistic player, importer, and supplier. The chart shows the pump price per liter of fuel in the recent months. The committee further noted that fluctuation and scarcity of petroleum products in Uganda is not singly attributable to lack of a single national importer and supplier, but rather to a number of factors, all of which need to be historically addressed. These include fuel stock levels. Although Section 26 of the Petroleum Supply Act requires every licensee to maintain minimum working stocks of petroleum products as prescribed by regulations in order to assure continuity of the petroleum supply, these regulations are not in place. The Ugandan fuel market has numerous players with the biggest market share operated by multinational companies who determine their individual stocking and price decisions. The committee noted that the UNOCO's stock levels are 30 million, but UNOCO lacks consistency in replenishing the reserves. The chart below shows volume and value of petroleum products imported by Uganda monthly. Transport notwithstanding, UNOC does not possess the financial muscle to facilitate to provides that, clause 2 of Article 21 provides that without prejudice to clause 1 of this article, a person shall not be discriminated against on the ground of sex, race, color, ethnic origin, tribe, birth, creed, or religion, social or economic standing, political opinion, or disability. Article 40, Clause 2, entitles every person in Uganda to the right to practice his or her profession and to carry on a lawful occupation, trade, or business. The only exception to the enjoyment of these rights and freedoms is under Article 43, which prohibits a person shall not from prejudicing the fundamental or other human rights and freedoms of others or the public interest, which shall not permit political persecution, detention without trial, any limitation of the enjoyment of the rights and freedoms prescribed beyond what is acceptable, demonstrably justifiable in a free and democratic society, or what is provided in the Constitution. The committee notes that the proposed limitation of the enjoyment of economic rights through the creation of a monopoly is not justifiable in a free and democratic society. The committee noted that the clause contradicts Section 6, subsection 2, paragraph A and B, as well as Section 7F of the Principal Act, which obligate the minister to make legislation and regulations to secure adequate supply of petroleum products at competitive, I emphasize at competitive cost for all consumers, promote the increase of opportunities for regional petroleum trade, and encourage a diversity of supply sources, as well as the observance of the principle of free market economy and fair competition. The clause further offends Section 30 of the Principal Act, which prohibits activities against fair competition. The committee further noted that the Competition Bill 2023, as passed by Parliament, though not yet assented to by the President, was a government bill whose policy objective was to promote sustainable, fair competition in Uganda and prohibit anti-competitive agreements which have an adverse effect on competition in the market. It is important to take cognizance of its intended principles, which received cabinet approval before it was tabled in Parliament. The committee noted that Ugandan courts have struck out provisions of law that grant the government preferential treatment over private parties. For instance, in the case of Attorney General versus Ostrako, Civil Appeal number 32 of 2002, and Uganda National Resource Authority versus Vivo Energy Uganda Limited, High Court Miscellaneous Application number 209 of 2014, and Spedaga Interflight Uganda Limited and 3 others versus Attorney General and another, Constitutional Petition number 85 of 2011. Further, the committee noted that the bill violates international instruments, including the Commercial Competition Regulations 2004 and the East Africa Community Competition Act 2006. The Commercial Competition Regulation prohibits member states from anti-competitive practices. Similarly, the East African Community Competition Act, to which Uganda is a signatory, stipulates as some of its objectives: protecting all market participants from freedom to compete by prohibiting anti-competitive practices, protecting the opening of partner states' markets against the creation of barriers, interstate trade, and economic transactions by market participants, guaranteeing equal opportunities in the community to all market participants in the community, and especially to small, medium-sized enterprises, guaranteeing a level playing field for all market participants in the community by eliminating any discrimination by partner states on the basis of nationality or residence. The committee noted that through interactions with the stakeholders showed that there are other players who can either work directly with UNOC or work alongside it to ensure competitiveness in pump price and guarantee security of supply of petroleum products. The committee also noted that past experience of monopolies, including Umeme, the Enrico Agreement, the Iron Ore Agreement, and the secretary instrument that was issued, the Euracement Agreement, have cost the country money and set a bad precedence for monopolies in Uganda. Thus, the committee's decision against creation of monopoly for the petroleum sector. Committee recommendation. The committee recommends that clause 1 be deleted from the bill. Interpretation. Clause 2.6 to introduce a definition of licensed oil marketing companies to mean a person granted a petroleum supply operations license under Section 17 to import petroleum products into Uganda. Committee recommendation. The committee recommends that as a consequence of a rejection of Clause 3 and Clause 2 be deleted as well. Supply chain of petroleum products. Clause 3 of the bill seeks to substitute Section 29 of the Principal Act, which allows any person, whether Ugandan or foreign, to participate in all or any activities of the supply chain by restricting the importation and supply of petroleum products destined for the Ugandan market to the licensed oil marketing companies to be undertaken only by UNOC. The clause, however, empowers the minister by statutory instrument and exceptional circumstances with the approval of cabinet to nominate such other person to import and supply all or a portion of petroleum products. The exceptional circumstances are where UNOC fails to import and supply petroleum products in any given month or where UNOC becomes insolvent. The clause further obligates all licensed oil marketing companies to purchase all of their petroleum product requirements from UNOC or other nominated person by the minister. Committee observation is, the committee noted that UNOC is incorporated as a limited liability company solely owned by the government of Uganda with its functions set out in Section 43 of the Petroleum Exploration, Development and Production Act 2013 to include to handle the state's commercial interests in the petroleum subsector, to manage state participation in petroleum activities, and to manage the business aspects of state participation. The committee further noted that under UNOCO's Memorandum of Association, the objects of the company include to manage the state's commercial interests in the petroleum subsector on behalf of the Republic of Uganda, to manage state participation in petroleum activities, including its business aspects. The committee therefore noted that there is no legal deterrence to UNOCO's participation in business in the petroleum sector. It should trade alongside other players, but perhaps offer more competitive prices that shall outcompete other players to create for it a natural monopoly. Committee recommendation is, the committee recommends that the clause be deleted for buttressing the already rejected monopoly proposal, but also for providing for UNOCO's right to engage in petroleum trade, a position that is already provided for in other legislations. Petroleum products to be imported and supplied by UNOC. Clause 4 introduces a third schedule which lists the petroleum products to be sourced and supplied by UNOC to include premium motor gasoline or super petrol, automatic gasoline or diesel, Jet A1 and dual purpose kerosene. Committee recommendation. The committee recommends that the proposed third schedule be deleted consequential to the rejection of the bill. Right Honorable Speaker and honorable members, I beg to report.
Thank you for the report. Dr. Tala, thank you for the report.
I rise to support the report of the committee, which is also the majority report. Madam Speaker, this country collectively sat here as represented by their MPs, and we made the law to put in place an institution that would take care of our interests in the oil sector. And that is the Uganda National Oil Company. One of the major mandates is to take care of our interests collectively as a people. It beats my understanding when I hear some quarters of this country, some members, trying to want to put their interests in private companies. How can that be, Right Honorable Speaker? The Uganda National Oil Company, we should collectively empower them to take care of our interests. It's like a child at home. When a father is at home, those children, the parents take care of them. When they are sick, they must be taken to hospital. When it comes to school, you want the best for your child. And therefore, the Uganda National Oil Company, for me, it is not right for us to use middlemen in Kenya to feed us when we could empower our own, our child. We are a government, we are a people. There is nothing better than empowering our own institutions. We are always crying here about strengthening institutions. And this is an opportunity to strengthen our own institution that can take care of our interests. What is wrong with our own child? Partaking of those profits the third parties are taking in Kenya. And for me, the way I see it, right, Honorable Speaker, because the member alluded to a lot of laws, and I'm a lawyer. Under Article 40, where economic interests are provided, this law does not seek to stifle the businesses of these private companies. They can still get these products from UNOC as if they are getting them from those third parties they are getting from in Kenya. And business will be done without any stifling. So no one is being thrown out of business. It is just empowering UNOC to act as if it were those middlemen in Kenya, earning a lot of money from us.
Honorable members, UNOC is a government entity. Let's run away from the dependency syndrome. We want to depend on those brokers. Huh? Leon.
We are tired of our prices being controlled by neighboring countries. We are not against other players, the private companies in this business. But UNOC is here to serve the interest of government in the oil sector.
Then after Nathan, I will have Katesh.
Thank you very much, Madam Speaker. Madam Speaker, the bill is more of empowering UNOC. Yes, the question my honorable colleague is discussing or trying to debate about is how UNOC will operate. My sincere request to you, Madam Speaker, guide us. Should we first deal with empowering UNOC? Then we get to on the part of how UNOC will operate. Because the discussion, yes, wait a minute. Look at the bill. The bill is not mentioning about Vitol, it's not mentioning about Shell. The argument is, why don't we first deal with empowering UNOC? And then we all agree. Number two, we come on how do we empower UNOC to carry out the operations that we have given in the Act. So, Madam Speaker, kindly guide us on how we should move.
Members, the issue is about UNOC. But what Honorable Nandala is raising, is also a food for thought. Now, Nathan is raising an issue that we've already entered into an agreement with Vitok. How did we reach that level? And that is something that should be corrected in the law. That before you enter into such an agreement, it must be approved by this House. Huh?
Thank you very much, Madam Speaker. Madam Speaker, when we come in the House, I want to tell you, I am one of those who comes here for the interest of the country. If you have personal interests, I'm not interested in them. Yes, I want to tell you that. Because what I'm trying to explain, I have not raised anything against, please. Hold on one. Madam Speaker, I want to beg you to do
Can you conclude?
Yes,
I've understood what you're saying.
Yes, no, Madam Speaker, I want to beg you that maybe again you should do an induction for members of Parliament. Because the way they are behaving, they are making the House look...
The issue is, and what countrymen will ask us, that we've knocked ourselves before on the matter of Umeme, in the matters of Bujagali, in the matter of Dura Cement, in the matter of Peneti, in coffee,
and in the matter of Ruvowa Hospital again. And we are coming back as the same house. How shall we explain to the people that we are the very same house that comes here and legislates after agreements have been entered into by government without consulting the people?
This is the party started, and I'm happy that my brother Felix Okot is around. Madam Speaker, there are so many fuel companies. There's BP, there's Excel, there's Total Energy. There are so many. And if government of Uganda wanted, it would have come up and said, we cannot have only one, but many. And if you have many, there would be no issue being raised. And if you want us to empower UNOC, we can do it. Even we can do a tax levy on fuel and say 100 shillings will go towards empowering UNOC so that tomorrow they are capable to run on this own. We did it to New Vision, and after New Vision had picked up, we allowed other monopolies to do. We said nobody will advertise anywhere in Uganda on government contracts apart from what? New Vision.
Thank you.
Madam Speaker, I want to conclude. I want to conclude just small things. Madam Speaker, you need information to help. I was in a meeting where a group called SIPA. These are calling themselves something in a name. Sustainable Energies and Petroleum Association. I hope the chair was on that meeting with the chair in the committee. And they were arguing, they were saying they wanted more items to be added on the list. But the people who have SIPA are basically members of Vivo Energy. And Madam Speaker, they came to support. Then when members asked, where are other members of SIPA, like Total, like Corex, they said they were busy not coming. And I would like the chairman sent the CID to pick the document. They came without no document. In conclusion, Madam Speaker, I want to state this, that one, nobody is fighting UNOC. What we want to do is let UNOC come here with a budget. We give them money to go to the refinery. We shall give a guarantee. Two, many companies appeared before the committee. They said they have capacity. Madam Speaker, the moment you sign a contract of 2.5 million liters by Vito to Vito, that one government of Uganda will never go bust. That company is going to go all over the world to source money and come and supply. And the money they are going to get has interest. First, there will be interest on the money, there will be their margins, and there's a monopoly. The moment you create monopoly in this country, the same prices are going to go high. I would plead, members, that for now, the committee should be funded. Madam Speaker, if you agree, this committee should be funded to go and visit oil refineries. We can send you either Singapore or Saudi Arabia or even in Dubai you'll get. You go and learn how fuel is dealt at a refinery. Madam Speaker, a refinery also, it is like a maize mill, where people who have deal in maize take to the maize mill to mill. Then there will be buyers. Are you getting it, Madam Speaker? Even those who bring crude oil come and refine their crude oil to a finished product, but that is a maize mill now. So it is the one which may be knowing who are the buyers. But the owners of the oil are those of the crude what? Oil. Nobody should lie you, it is the refinery which is a problem. The problem is the crude oil dealers, and the refinery knows who are the crude oil dealers and who can buy fuel from the refinery. Madam Speaker, when they demonstrated that picture there, that picture was just trying to take us away. The true story is that most of the big companies, like let's say Shell and Vivo, for them, if you have a managing director in UK, his salary, there will be a portion on that liter sold in Uganda. So that liter you buy here in Uganda has cost overheads up there. Now you'll discover that there are small dealers who have no big overcost. Their pump price is too low because the overhead costs are too low. And that's where we could be fighting and say, is it possible for you to go to the refinery and get the crude oil and we deal with it, but not to be told which is going to be very expensive element.
Honorable Kat.
First of all,